Hi, welcome to this session on hardship and immigration law. In this module, we're going to begin to explore the concept of qualifying relatives for cancellation or removal hearings for undocumented immigrants in immigration court proceedings. So, what is a qualifying relative? Well, a qualifying relative is either a spouse, a child, or a parent of an undocumented immigrant. However, that person, the parent, the child, or the spouse, must be either a U.S. citizen or a lawful permanent resident. If they're not, they will not count as a qualifying relative. In addition, the child must be under the age of 21. Any sons or daughters of the undocumented immigrant over the age of 21 will not count for purposes of being classified as a qualifying relative. What's the significance of a qualifying relative? Well, when the judge analyzes the hardship that will be caused to the family by virtue of the immigrant being deported, the judge is required to assess the hardship to any individual that is a qualifying relative of the undocumented immigrant. So if the spouse is a lawful permanent resident or U.S. citizen, their hardship will count. If there are any children that are U.S. citizens or lawful permanent residents, their hardship will count. If there are parents of the undocumented immigrant and they will suffer hardship because of the undocumented immigrant's departure, and they are U.S. citizens or lawful permanent resident, then their hardship must be explored by the court. Now, qualifying relatives are not the only hardships that will be caused by an undocumented immigrant being deported. However, their hardships are the only hardships that the judge is required to consider. Therefore, when assessing a situation of the individual having to leave the country, the judge will focus in on the qualifying relatives. I think, however, that in preparing a case, it's not the right course of action to solely focus on the qualifying relatives. So the best way to explain that is by looking at an example. So by now you should have downloaded the three handouts I've given you. Now the first one is the definition of qualifying relatives for immigration court. The second one is a hypothetical situation regarding an undocumented immigrant named Harry and his family. Let's explore that situation. Harry is an undocumented immigrant. He entered the United States in 1994 and he's never left the country since then. He has no convictions, no arrests. He was recently apprehended by immigration officials and placed in deportation proceedings at immigration court to face removal charges. And as you likely know, this can happen many ways. Maybe there was a raid at his job site. Maybe there was a traffic stop. Maybe the neighbors got into a fight, or he was simply in the wrong place at the wrong time, and he was interviewed by some law enforcement officers, and this particular officer did not like immigrants, so he contacted ICE and basically gave the information on Harry to them. There's a lot of ways that an individual can be apprehended by immigration officials even though they've done nothing wrong. Now, Harry met Wilma. Wilma is his current wife. At the time he met her, she was a lawful permanent resident. It was in the year 2005. They started dating about a year later, and several years later, Wilma in 2011 became a U.S. citizen. They were married a year later in 2012. Harry has three minor children. Mike was born in 2007. Frida was born in 2010. And there's a third child, Ernie, who was not born in the United States. He was born outside the U.S. in 2002. Ernie's mother is Darlene, Harry's first wife. Harry and Darlene were divorced in 2004. She was a lawful permanent resident at that time. At the end of the divorce proceedings, the court gave legal and physical custody to Ernie. Wilma has two parents still living, Maria and David. They're both U.S. citizens and they're still alive. Wilma has a U.S. citizen sister, Shirley. She's alive. Henrietta is Harry's mother. She lives 2 blocks away from Harry and Wilma. She doesn't work. Now, why did I give you an outline of individuals that probably are not qualifying relatives? Because we need to explore hardship. and you explore hardship by first evaluating the situation of qualifying relatives. So let's begin. Is Wilma a qualifying relative? Clearly. She's the spouse of Harry, and she's a U.S. citizen. In most cases, the immigrant spouse, if they're married, is probably going to be the individual with the greatest degree of hardship. So their situation has to be explored in full detail. Mike and Frida are children of Harry's that were born in the United States. They're clearly qualifying relatives. They're under 21. They were born here in the U.S. What about Ernie? Ernie was born outside the United States. So is he a qualifying relative? Well, not so fast. Slow down there. We don't know if he's a permanent resident. His mother was a permanent resident when he was born. Did she ever file papers for him? Did she ever legalize him? Well, what about his current mother-in-law, stepmother? What about Wilma? Perhaps Wilma has immigrated him as a stepchild. Well, then he would be a qualifying relative. But let's say that neither his biological mother nor his stepmother immigrated him. Well, Wilma needs to hop to it. She needs to immigrate him, because if she immigrates him, then he becomes a lawful permanent resident. And as a lawful permanent resident, he can't count as a qualifying relative in his father's case. So, why did I bring up Maria and David, the U.S. citizen parents of Wilma? They're not qualifying relatives. They have no connection to Harry, other than that they're the grandparents of his two children that were born to him and Wilma. Well, let's say Maria suffers from a life-threatening disease, and she needs to stay on heavy medication, and she needs to go to a doctor quite often. And the one who takes care of her the most is Harry. Harry drives her to the doctor. Harry goes by every day and takes care of her. Harry takes care of Wilma's father as well. Well, their hardship still doesn't count, and their hardship doesn't count in Harry's case. Well, not directly. But Wilma's close to her parents. And let's say she loses one or both of them. And Harry's played an instrumental role in their life, keeping them near Wilma. Well, will Wilma suffer with their loss? Yes. Will Wilma suffer if Harry leaves the country because he's deported and he can't take care of her parents? Yes. Well, shouldn't those issues be explored as part of the hardship she might suffer if Harry's deported? Absolutely. And the same goes for Shirley. Perhaps Shirley's the one with the big disease in Wilma's family. And perhaps they take care of Shirley, or they take care of Shirley's children. And Harry plays a major role in that. Well, without Harry around, won't there be an impact? Mentally, psychologically, perhaps physically and financially as well on Wilma? Oh, yes. So that would impact Wilma's hardship, the degree of hardship. It would increase it. So shouldn't the court know about that? Absolutely it should. How about Henrietta, Harry's mother? Well, there's no indication that she's a permanent resident or citizen. She might well be, but assuming she isn't, does her hardship still impact Harry? Well, yes. Well, maybe he takes care of her. Or maybe she plays a major role in raising Harry and Wilma's children. So her impact on Wilma is great, because if Harry is forced out of the country, he's forced to leave and return home. And let's say his mother says, I'm going with you. I'm leaving with you. Or his mother loses the closeness to Wilma and the children. Is that going to cause an impact on Wilma? Absolutely. Is that going to cause an impact on the U.S. citizen children, Mike and Frida? Absolutely. Should that count? Should that be a factor of consideration for the court in terms of their hardship? Yes. So it's not the impact directly on Henrietta, but it's the fact that Henrietta's hardship may indirectly affect the hardship of Wilma or the two U.S. citizen children, and that would definitely increase their hardship. And the court should hear about that testimony. So, what about Darlene? She's an ex wife. She has no role in this. You sure about that? Think about it. Darlene lost custody to Harry. Or maybe she agreed to give him custody. Why? Well, because the court thought Harry was a pretty good dad. Or he was the better of the two in terms of the placement. The best interest of the child was to live with Harry. Wow, that's interesting, especially because at the time of their divorce, he was without immigration papers. So you would think that Darlene would have been granted custody by the family court. But no, it was Harry. So let's say Harry and Darlene don't have a bad relationship. Could Darlene be a valuable witness? Absolutely. And her testimony would be highly relevant on Ernie. So even though she's divorced from Harry, could she immigrate her son? Yes, just like Wilma could. And could her testimony on how much her son would suffer become highly relevant for the court? Yes, absolutely. So when we're looking at qualifying relatives, the law strictly narrows who counts as a qualifying relative. The law strictly limits whose hardship is to be counted. However, there are other individuals around that qualifying relative, brothers, sisters, grandparents, ex wives, who all have valuable testimony, who all may suffer as a consequence of Harry being deported. And when they suffer, their hardship may impact the hardship of the qualifying relatives. So they should be considered. Their hardship should be considered, albeit indirectly. We're going to explore that in a subsequent video. Thank you for listening, and hopefully I've simplified the concept of qualifying relatives for you.